Data law issues arise in many different contexts. This week we'll look at one of the many ways the law deals with whether data should or should not be kept out of the public gaze. We'll be looking at the recent High Court of Australia decision of Rinehart and Rinehart.
That's what non-disclosure agreements or confidentiality agreements are all about. So where information is confidential, often parties will back up that confidentiality by a contract. It becomes a bit problematic where the information isn't actually confidential in nature. The law is much stricter where parties are trying to put a gag, in effect, on information that's already in the public domain. It's possible, but it's a bit trickier from a legal point of view. Generally they are. So generally once the parties enter the court system, it's a public system and information is publicly available. With a view to that, there is a way around that, and that's in an arbitration agreement. So some parties will say, well, we don't want our disputes in the courts. We would rather have a private, independent arbitrator to determine our dispute, and we want to keep that confidential. And that's a valid way of handling an agreement to keep information out of the public domain in a dispute situation. Now, that's a very big question, because the argument is, well, we have a contract and the contract says that we'll have a confidential arbitration, but if one party says that the contract itself is invalid, what happens to that dispute as to whether the contract to arbitrate is valid or invalid? Some very fine minds legally internationally have exercised their attention on that particular issue, and it is the one that came before the High Court of Australia in early May 2019. In the decision of Rinehart, they had agreed to keep their disputes confidential under an arbitration clause, but the appellants challenged the validity of the arbitration clause and argued that because it was potentially invalid, the scope of the arbitration shouldn't extend to a challenge on the validity. In that case, the High Court said, well, everything depends on the proper construction of what they agreed, and said the parties clearly intended here that they did not want issues in dispute between them to be in the public eye. There were two key factors there. Some of the respondents at the time were engaged in highly sensitive, very important commercial discussions. It would have been seen to be inimical to those discussions for a publicly aired dispute to be permeating at the time. Secondly, the relationship between the parties. It was ultimately an intra-family dispute, and the court was much more disposed to finding the objective intention of the parties in a family dispute was to keep matters out of the public eye. Ultimately, if you're in an agreement situation and you're looking at non-disclosure provisions, be clear about what you want it to cover.